New Close-Up Deep Action. We created it to give the world 3 times fresher breath and eliminate up to 99% of germs. Maybe we went too far. There's an outbreak of freshness. Now the best ever from Close-Up. 3 times fresher.
Newsfile is brought to you in association with MTN, everywhere you go, and Bank of Africa, as strong as a group, as close as a partner.
Good morning and welcome to Newsfile, your most authoritative news analysis show. I'm Samson Ladi Ayenini. Under the circumstances of this case, there was absolutely no sound legal basis for the pursuit of the claim by Waterville and Woyome against the government of Ghana. It should have become very clear to whoever was in charge of directing affairs at the AG's office that the claims of Waterville and Woyome against the government of Ghana cannot hold water. Words forced out of the Supreme Court by citizen vigilante Martin ABK Amido. I will get you more quotes from my notes of the judgment as we discuss the fallouts. Of course, there is also the mother of all suits, the Supreme Petition. More and final warnings to lawyers, plus fears of delay by controversy over actual numbers of pink sheets. Is President John Mahama in contempt for declaring he won't lose the case? And finally, we shall take you to the Kotoka International Airport to see if it is now difficult to smuggle an ounce of coke through that airport. We'll be right back.
Do you dispute that what you have there is a register given to the MPP?
I can check and tell you what the truth is tomorrow morning.
I'm suggesting to you that this is a register supplied to the New Patriotic Party.
My Lord, I object to this question. Oh, the witness has stated that he is the custodian, he is ready to check and bring it back tomorrow.
Why is it quite fair to you? He says, I'll go and look at it and come back tomorrow.
Well, if we bring the soft copy, you'll need time again to check on that. They're always shifting the goalposts. We will never get there. We never get there.
He needs it to check, my Lord.
Dr. Alfaraja, can you return my document to me?
My Lord. What is Mr. Addison afraid of?
You asked him, he said, give me up to tomorrow, I'll check it.
They seem not to trust me. They want me to trust them. I don't one bit trust them. One bit. I don't. We will not, the document can be in the custody of the court. I will not let them take this document away.
Isn't it sad? You know, these statements being made at the back.
Well, I have said what has not been said, their attitude. I wanted my document. Look at the attitude they put up here. It's so sad. I'm sad.
So if you decide to take the document back, what will you be comparing with?
They should bring their copy. I will leave it to the court.
That is all that they
I do not think that I will leave it to this witness.
No.
They have been so untruthful throughout these proceedings. I don't trust them one bit.
But those statements are clearly wrong. You see, well, you see, I think this message has been sent.
My Lord.
Please listen to me. When I'm talking, you have to keep quiet. You see, this message has been delivered so many times. Whatever you say is to the bench. If you say you don't trust, if you use any negative words, they impact negatively on the bench. So you shouldn't be using these words. That is clear and simple. I don't see why you don't get it.
The insinuation of what you said is that the bench has not been fair to both sides on equal terms. And that one, I do not think is a fair castigation of us. The clear implication of this is that we now have to apply the rules of the ethics, the rules of courtroom procedure. We've always said that lawyers appearing, both at common law under all the statutes, under the legal profession, as are officers of the court. We have those powers to deal with the conduct of any lawyer appearing before us. So many can walk you out, we can deal with you for contempt, we can refer you to the disciplinary committee. All these are ample powers. But we feel that, power is for the benefit of human beings, not for its sake. So we've tried to, let it, that if you feel that we are failing in our duty and we start punching, and that is not our fault. So, okay, finally, and all you here are witnesses. The slate for the final time has been wiped.
I thought that there wasn't a finer time than today, marking the 21st anniversary of our party, to visit the party office and to express my appreciation for the work that is going on and to encourage you to continue with the good work and to also encourage you that our victory was won cleanly and fairly. And that justice will be served and cannot come to any other conclusion than acknowledging the very transparent, free and fair victory that we won at the election. The case continues to strengthen the base of the party, because it is the base of the party that supports government to be able to carry out the manifesto that the party took into the campaign. And so I won't say too much, but just to say that I came for us to have a little tete-a-tete just for a few minutes, and we'll continue with the work that we're doing.
You're welcome back. This is Newsfile on Joy 99.7 FM. You're watching us on TV. This is your multi-TV Joy News channel. I'm Samson Ladia Yanini. This platform, we put Ghana first, and this is obviously your most authoritative news analysis platform around the region here. Now, as I've already introduced the matters to you, we'll go to the Supreme Court and we'll begin with the partial victory won by Martin ABK Amidu yesterday, the citizen vigilante. He's very excited about it, even though he didn't get all that he was seeking to get, and would also continue to stay in the Supreme Court and look at the Supreme petition itself. and matters arising thereon, there have been warnings to the lawyers again, and this time we are told, and all of us, the whole world, were called to be witnesses to the very final warning being sounded to the lawyers, and that the next time, if they breach the rules and code of ethic, they might suffer the wrath of the judges. I suspect contempt, or as Justice Atugba said, they would be referred to the General Legal Counsel. As you are aware, yesterday there was some other reference to the General Legal Counsel. We'll look at all of those matters. And also a key point in the Supreme Petition discussion will be President John Dramani Mahama, who is the first respondent in the case, who has gone to town to say that he's very certain of victory and that nothing other than victory will be the result. Did he overstep his bounds? And is he in contempt of the court as a party himself? We'll look at that portion, and also the fear that the controversy over the actual numbers of pink sheets filed at the registry or served on the respondents may delay the process. We'll look at that one also. And as I told you earlier, we will try to enter Kotoka International Airport to attempt to go to the UK or the US with something in our bodies and see if the security there will catch us. It's just coke. Right? My guest in the studio right now, and we are waiting for Gabi Asare-Ochiridako, Executive Director of the Dankwa Institute, and who is also a legal practitioner, to join us. But right now I have Abdul Malik Kwekubako Jr., regular panelist. He is the I say editor-in-chief sometimes, yeah, editor-in-chief of the New Crusading Guide newspaper. Abdul Malik, good morning and welcome.
Good morning, my brother.
And then we have Kofi Adams. He's the Deputy General Secretary of the NDC. Good morning and welcome.
Good morning.
Okay, the last time I introduced you as someone else. So it's interesting to be able to introduce you as the Deputy General Secretary. He's been reinstated long ago. Now, Nana Ato Dazi, former Chief of Staff. He's also a lawyer, and he's currently with the third respondents in the matter in the Supreme Court. Good morning, Nana, and welcome to the show.
Morning.
Always good to have you on the show. Yeah. And straight away, gentlemen, I want us to start with the very latest news that hits the country yesterday from the corridors of the Supreme Court. It is about Martin ABK Amido. He went to court and sought to have the contracts, as it were, that were signed between Waterville and the government of Ghana for the rehabilitation of the stadia for the CAN 2008 project set aside or declared null and void because they were in contravention of Article 181 of the 1992 Constitution, which gives a requirement for any such international business transaction to have been laid before Parliament and same to have been approved before it could become operative. So yesterday the court described it many times as the inoperative agreement. Now, he got part of what he wanted because the court's decision was that indeed and in fact the agreement was an international business transaction, and to the extent that it was not submitted for parliamentary approval, it was null and void in breach of the Constitution, and so was of no effect. Sorry. And then all the monies that have been paid as a result of that contract to Waterville are ordered to be refunded to the coffers of the state. Well, the portion where he was seeking to have the court ask Wayomi also to refund the monies he has received was not granted, because by the court's decision, those are jurisdictional matters. On the basis of that, they are leaving it to the commercial court, which is presently handling that matter, and also the financial division of the court that is also handling that matter to deal with. So that will just be about it by way of introduction. And also you remember that there were references of some of the lawyers involved to the General Legal Counsel for possible investigation and some punishment for some work that was done and appeared not to have been done in good faith. I'd like to start with Abdul Malik Kweku Bako Jr. I want to make a few quotations from Justice Dose, who gave a concurrent decision in agreement with the unanimous decision of the court. And he says that under the circumstances of this case, there was absolutely no sound legal basis for the pursuit of the claim by Waterville and Woyomi. In his words, he used the second and third defendants. But for the purposes of our viewers and listeners, I put there Waterville and Woyomi, because Waterville is the second defendant and Woyomi is the third defendant. So he says there was absolutely no sound legal basis for the pursuit of the claim by Waterville and Woyomi against the government of Ghana. He also went on to say that because of the material that was made available to the Attorney General's Department, he says it would have become very clear to whoever was in charge of directing affairs at the Attorney General's office that the claims of Waterville and Woyomi against the government of Ghana cannot hold water. There are a few other of my notes that I'll be sharing with you in the process of this discussion. I'll bring them to you subsequently, but there were words such as that the parties came together to create, to loot and share the resources of Ghana, as if a brigade had been set up for such an enterprise. Abdul Malik, it sounds to me that you have now been giving license to repeat the comments you made earlier, the very first discussion on this issue here in this studio, which attracted a threat of libel suit against yourself, Nana Kumia, and my little self.
That's right. Well, I think I must first single out Martin Amidu for praise.
He got a lot of praise from all the judges.
It was in good order, and that is important. It isn't as if he's the only one who articulated concerns and drove this matter. There were a few others, civil society groups, sections of the mass media, and so many other persons. But he took an initiative by pursuing the case at an appropriate forum, the highest court of the land. And what has come out is very significant. So I don't think it's an exaggeration at all to single him out for praise, and then we can proceed. I'm a sad person today as a Ghanaian. It isn't as if this is the first time that we have had some evidence of institutional failure driven by outright ineptitude on the part of officialdom. This is not the first time. I'm sure if we were to go do a historical recall, we may have instances since independence that we've had situations that were completely avoidable, and that with a little sense of vigilance and diligence, we may have avoided such a situation. But still, this is one of the most classic, cases, and it's worrying. As you indicated, the court said there was enough documentation of evidential value to have made anybody and everybody who had been entrusted with the responsibility of doing some job for the state not to have been trapped in this whole web of deception and fraud which occurred. So to be honest with you, you ask yourself, did we add anything after this kind of, straightforward, powerful judgment, well articulated, very concise? It tells the full story. What we were saying will be at the risk of even repeating ourselves and boring our viewers and listeners. But since you've given us the project, let's talk some in terms of the law. You see, and you are the lawyer, so you can educate me if I get it wrong. The point about the unconstitutionality or non-constitutionality of the non-existence of a contract. If you read the August 1st, 2006, and this document was available to people who took over from the MPP administration.
Which document are you referring to?
This is Joe Gatti's letter to Waterville.
Okay.
dated 1st August 2006.
The court made a reference to that one, and it said that this was the letter that gave the reasons for the termination.
That's right.
Because certain conditions precedent had not been fulfilled.
Yes, in the sense that it means the agreement did not become effective. I prefer to put it that way. The agreements never became effective. And it is stated here, one of the conditions, there were condition precedents that whatever had to fulfill, including raising funds, which they did not. But the significant one is this, that is 1711, the third one. It says rendering of a legal opinion by the Ministry of Finance and approval of the contract by Cabinet and Parliament of the Republic of Ghana.
Okay. Now, this is supposed to be a repeat of clause 17 of the agreement in Jogate's
That's
letter.
right, precisely. And Jogate was informing whatever that in view of your failure to fulfill conditions precedent, we have been compelled not to allow this contract to come into effect, and pointed out those conditions precedents, one of which was parliamentary approval. And parliamentary approval never took place. So I asked myself, when whatever in 2009 came up with that whole bogus demand for compensation for abrogation of contract, this document was available. And whoever was in charge, both of the Aegis Department as well as the Ministry of Finance and the Ministry of Sports, should have addressed themselves to such things. And indeed, in the process, even consult those who were in charge previously. Institutional memory. We have a system. It's an institutional thing. Okay? So in the absence, you remember there was a talk of, if you recall, a Deputy Information Minister told us on this very program that documents were missing. Some files were missing. So they were relying on the files of Waterville, which some of us said could be dangerous, because Waterville definitely would be selective in the presentation of documents because it wants to advance its case. Okay, so you ask yourself, on what basis did the mediation which the Attorney General ordered between Waterville and the government of Ghana, that was conducted by Mr. Ekoaono, it was a one-man mediation process. What basis, what was the basis? You go in there, Waterville made a lot of claims. Abrogation of contract, interest on the lost profits, all those things. What was the basis? The Supreme Court has proven today that there was hardly any basis, not an iota, for anybody to have actually encouraged Waterville to sit with Waterville for anything. There was another letter by Kojo Mpini, which was 28th October 2006 or 2008. That was written to Waterville, telling them that we do not owe you, and that all monies due you had been paid to Micheliti and Consa for onward delivery to you. That document was enough for anybody to have looked at, and then perhaps even to have invited Kojo Mpini for consultation on the matter. We will not be sitting here today dealing with the Supreme Court asking for that retrieval of that much amount of money. Look, I think there are consequential actions, and that for me is where the emphasis should be. Waterville is registered in this country. Immediately, the Attorney General's office and the appropriate state authorities should follow up. Olandi is in this country. He should be asked to report to the police and his passport taken immediately. He should be given timelines to report to the police. All their properties and things, we should put a focus on them. Because look, they can wind up and exit and then follow them to other jurisdiction. It will become even more difficult retrieving the money. We may even end up spending so much money retrieving this money. So quick actions, I'm not a lawyer, you are the lawyers, you know what quick actions the state can take to quarantine Waterville and its assets in this country to ensure that in the absence of the payment, if they don't pay, we have something to hold on to. I think that is even more important than celebrating the Supreme Court ruling. Otherwise, the ruling or the judgment may become empty, in my candid opinion. Other consequential actions can be taken. Okay. But to be honest with you, it's a split reaction. It's a mixed emotion. I'm sad, I'm excited. I don't know which one I must bring to the fore.
Just hold on, let me come to Kofi.
Yeah.
Kofi, tell me, I'm sure you may have followed the process so far and you're able to appreciate what has gone on. But when you hear the words of a judge suggest things like there was sufficient evidence or material evidence for the Attorney General's department to have known that the Waterville and Woyomi had actually, they had no claim whatsoever. Absolutely, and that's the word, absolutely no claim. When you hear that, what goes through your mind when you hear some things like that?
Yeah, good morning to your viewers and listeners. And let me say, I join Kweku in celebrating Honorable Martin Amidu. He has shown what a Ghanaian he is, and he's fought up to this point, and we must say congratulations to him. Because
I suspect you are not one of those who vilified him for the step he had taken.
Oh, sure. You knew my position on many of the issues on this same platform, how I thought that people should not unnecessarily rebuke him for deciding to do what he has done. And I don't think that Martin was taken on ostensibly because of his fight in terms of this case. It is more to do with other matters relating to someone who has appointed you and how you relate with that person. So we shouldn't mix the two things. It was unfortunate that it happened around the same time he was trying to take up this matter. And in one way or the other, it had a link with how he was handling this matter or others. His dismissal was more to do with other things other than his desire to fight and get justice for this country as far as this case is concerned. Because the same appointing authority did order the next Attorney General to continue the process initiated by Martin Amidu to retrieve any monies that have illegally...
The precision is important, not the Watergate case. There's an extension, a fine line that we must draw. Let's not confuse them.
And all along he had said that throughout the process, he had been expecting that Waterville will be added to the suit, and Waterville had not
never
been
up to
added
now.
to the suit.
That is what I'm saying. He initiated a process. He had not concluded that process. And the unfortunate incident of him being asked to vacate his post happened. The appointing authority then ordered the next person who takes over that, make sure you continue the process. What process has Martin Amidu started? The process of getting to include Waterville and all other companies that have questions to answer, which previously has not been included.
The process is sitting in court. It does not include Waterville.
Thank you.
What I'm saying is that he had started, but you knew very well that immediately Martin Amidu left, he subsequently initiated this process. And in the process he initiated, he added the Attorney General, who was supposed to also pick up this process. So you are the lawyers. You know that sometimes your hands get tied when it gets to a certain stage. But I think no matter what, we must still celebrate Martin Amidu for taking up the challenge. There are a lot of anti-corruption institutions in this country. I read a piece about him going to court alone, sitting on the side without even any solidarity from many of the so-called anti-corruption institutions in this country. So he deserves peace, he deserves support, he deserves commendation. I'm happy because this money that is to be paid back to our coffers will do a lot of projects and programs for us. So I'm very happy that government of Ghana or Ghana is going to be getting some money back that would have gone into someone's pockets. That is not the case, or that shouldn't have been the case. So I'm happy for it. When I hear things about enough evidence, then that is where the question arises to what people we pay in this country to work on behalf of the state, what they do. Do they go extra mile to seek for appropriate documentation before acting, or we act with disregard, thinking that, oh, the money I'm paying is not coming from my pocket. It is just my signature that is needed, and therefore payment is done. And so they don't go extra mile to look for documents that need pay. Like Kweku said, what also happens to records keeping? That documentation at an important ministry such as the Finance Ministry and then the Attorney General Ministry will be missing, and you have to rely on a private entity to provide you documentation based upon which you will act. And like he said, he's right, that Waterville and whoever is asking for money will not present full documentation that will expose the illegality of what they are doing. They will hide certain documents away from you. And we do know that sometimes if you allow judgment to go through, the amount of money you end up paying is higher than if you mitigate. You try to settle the matter through some kind of arbitration. So let's find out through possible further look as to what documentation was fully available to the actors when they acted. Did they have all the detailed documentation or not? I want to support the angle Kweku came from, that immediately the Attorney General and the security agency should team up and move on whatever they can move on and lay their hands on.
All right.
Hoping that they have already not started folding up and disposing of some of their facilities and properties that are in this country, which can help us retrieve this amount of money. So we must not waste time. Unless they give indication of appealing or asking for a review, we must quickly move and act to protect the country's and state interests.
Thank you very much. Your messages are welcome. 1422. 1422 is the text line. You can send me a mail also to newsfile@myjoyonline.com. I've got tons of your messages coming in, but I'll get them to the issues. Let's share on the issues rather than just simply praising Martin Amidu, because all the messages so far, that's what it is about. Congratulations to him and all, and suggesting, for example, that he has saved the country money that no other minister or even president could ever get to this country. Nana, I know that in this particular issue, you have a special, position or relationship because of your relationship to the former Attorney General Betty Mold-Idrisu, who was also specifically, as it were, mentioned, and Martin Amidu actually sought that some sanctions be taken against her to the effect that she had the benefits of the documentations that the court discussed. For example, there was reference to the failure on the part of the failure or refusal on the part of the Attorney General to defend the unconstitutional action brought by Woyome in the commercial court. Because they did not defend it, he got a default judgment. They attempted to settle it, so they came back together with a consent judgment, meaning they approved of the money that he was asking in addition, even though by the evidence so far, according to the court, he had been paid all the monies due him, and Waterville had also been paid all the monies due him. And that's specifically the affidavit that was sworn to by Samuel Nekwe Tete, who was Chief State Attorney, and filed it on behalf of the minister, suggests that they had, all of this information, because also Justice Tanko, who sat on that matter at the commercial court, is quoted to have said that he had no doubt that these information were available to them, and so they should have taken an action then.
Well, thank you very much. Again, it's a pleasure being here. I think you as you rightly put it, I think I have to put in a disclaimer immediately that counsel or solicitor for Mrs. Betty Mold-Idrisu, we've been through some challenging times within the last 2 or 3 years through the Public Accounts Committee. It's open, and we've maintained all along that Mrs. Betty Mold-Idrisu had acted professionally. We'd also said that she acted in her role as Attorney General and never for one moment in a personal capacity or with any intent to, join in any conspiratorial arrangement to defraud the country. I think that the Supreme Court has spoken, and we must all respect the court. That is what it is.
Yeah, but the Supreme Court,
yes,
the Supreme Court doesn't exactly support your position.
Yes.
Because the reference to, for example, the letter written by the former Deputy Minister of Finance that repudiated the claim by Woyome and challenged his local standard in the issue, that he was no party in the first place, and if anything at all, he had been paid whatever was supposed to have been paid him through Waterville. And then you had Tete and Co. also writing to tell the Attorney General that the letter that Woyome wrote to her saying that he was due so and so amount are wrong, and that he had he was not deserving of any payment, and yet we sat back and didn't file any defense.
I'm just saying that we must respect the ruling of the Supreme Court. The Supreme Court did not order that sanctions should be exacted against Betty Modidusu. The Supreme Court did not say it should be referred to General Legal Counsel. Yeah. The Supreme Court did not say that her conduct was reprehensible, and not that. You see, that's the point I'm making.
Yeah. And it declined that invitation on jurisdictional basis.
Absolutely. Yeah. So it didn't say it. So I don't want us to get trapped into the situation where we say, oh, they said the lawyers should be referred to. I'm saying that the court said that they did not find any issue concerning the AG's conduct which needed interpretation. You get me? If anybody still thinks that there's something to investigate or to look into by way of the conduct of Betty Modidusu, it's at liberty to do that. But I'm saying that yesterday's ruling did not, damn Betty Modidusu. And that's where the position will come. I would want to, from beginning, say that I'm equally, happy for my personal friend and colleague, Martin Amidu. For some, I'm sure many Ghanaians, this is the first time they see somebody rise up to that level. But look, we worked with quite a number of such persons in the 80s, in the revolutionary age. Hard, tough. Like Martin Amidu will fight to the last. And many of them still exist. And I know what the stuff that Martin Amidu done.
The court encouraged Ghanaians, especially civil society organizations, to emulate Martin Amidu's example where the state is failing.
The point I'm saying is that we must commend Martin Amidu, but we must also come to a realization there are many more Martin Amidus in the system. They've worked hard over the last 20 or 30 years. Many of them have been maligned and all that. And I'm saying that I sit next to Martin Amidu and I know the stuff he's made of. When he had a challenge, at a point in time, you remember about he was on radio and all that, I made an intervention. And I said that Martin Amidu must not be maligned. And that he had contributed so much to this country. You understand? But at the same time, I called on Martin to exercise restraint. That there's a way that things are handled, Unfortunately, you see, what the point I'm trying to make is that this whole matter has been trapped in so much politics that for a very long time, instead of focusing on the issues to find out what was done right or wrong, it became a tussle where parties had jumped into it and they were fighting. We appeared before the Public Accounts Committee in relation to all these matters. And everybody knows, almost exactly 1 year ago, we had tough times before the Public Accounts Committee because that committee had clearly been polarized. Members were sitting on the committee, with all due respect, who were coming to a conclusion even before the issues could be settled. Martin Amidu needed not have gone to Supreme Court. If Parliament, in its supervisory role, were acting properly, without due respect to the honorable members, Public Accounts Committee had an obligation to look into the documents, to look into the records, and dispassionately, a bipartisan body, say that, look, this payment is not right, or this is not right, or that is not right.
Like Joe Gatte's letter said, the matter had not gone to Parliament. So why do you blame Parliament in this?
No, exactly. But I'm saying that the decision of Supreme Court yesterday, it's about public accounts, you understand? And within our constitutional framework, we have a body that can examine all these
things. It is for Cabinet to first submit the documentation to Parliament.
I'm saying
if you don't submit it, you are not inviting them to it.
I'm saying that each payment that is made from the Treasury is subject to the supervision of Parliament and the subcommittee. And I'm saying that you can understand how I feel about it. Because 1 year ago, I mean, we could barely move forward on some of these matters. But let me not get bogged down. I'm just making a point that Parliament has a role in this. You don't have to have go to Supreme Court to secure this. Thank God Martin did, you know, and I'm saying that I'm very happy and I congratulate him by this, but I know that Martin has done more than this even for this country. And there are many more Martins, you know, who we worked with in the past. For those PNDC, hard nose.
Very finally, a very last point for you, and then I'll get to Gabi Asari Ochiredako, who has joined us. He's been here in the last 10 minutes or so. Good morning and welcome. 15 minutes.
No,
okay.
okay.
Now, I'll say...
No, if I would just... I just sorry. You know, when you come to the substance of the matter itself, the Supreme Court says that the agreement, you know, itself, the whole entire agreement, not only a portion of it, did not go to Parliament. You see, this is Article 1815, you understand? It did not go to Parliament. So what agreement are we talking about? Are we talking only about the Waterville thing? You see, right from the word go, as Kweku Riley said, there were payments to Micheletti and others.
They were the subcontractors.
Yes. The subcontractors.
Subsequently took over the project.
Did those contracts go to Parliament? You get me?
No. The point. If I may come in here, the point that you can continue.
Between Micheletti Consa
I know.
on one side.
I know. I'm saying
and
that
their contracts didn't have to go to Parliament.
The principal contract on the establishment, the refurbishment of the
was to Waterville.
For which they said the money due Waterville has been paid to Consa and Micheletti, and that they should go and collect it. Did that work that they do? No, but the work they did, for which they were asking them to collect from Consa and Micheletti, did it go
to Parliament?
Parliament for agreement?
You see, I'm saying that
means they did some work.
No, sir. Just a minute.
Is it a deliberate attempt to confuse the issue?
Oh, no.
So let's deal with it. I'm asking a question.
Please, let's have a very open mind.
Finish your point.
I'm sorry.
Just like that. I'm saying that we have to learn lessons out of the Supreme Court thing. Now, when the Supreme Court says that these agreements are agreements in the nature of international business and economic transaction, which must go, that this particular clause...
And there were loans that were being taken.
Yes, these are very difficult interpretation. The effect of this ruling, like a couple of rulings which have gone by, is going to have a very huge impact on our own businesses. As I said, I personally participated in the Balkan Energy case at the Supreme Court, where, for instance, Zenith has over $30 million trapped for work done, but the contract ultimately was said to, the bigger contract was said to be, unconstitutional. You get me? The realm of our international and local business it will have to be redesigned. Actually, there is something that Parliament has to do. Under the law, Parliament has to make certain regulations and laws to align and get this particular, 1815 more effective.
That is
it has not been done as yet. That's why it's creating so much room for deflation as to which one is international business and what is not.
So the state institutions, from wherever you look at it, are failing this country. This has been there for a long time, since 1992, and the Parliament has not effectuated it by, introducing the appropriate legislative instrument for it. Now, let me get to Gabi. Gabi, following the outcome of the case, what are your comments?
First of all, let me begin from from where Monsignor ended. And I think he's absolutely right. It's really scandalous in terms of how Parliament has been, shall I say, negligent in adding meat to Article 181, Clause 5. Because what does it say? It says this article, and the Article 181 deals with international loans.
That is so.
And it goes on to say, with the necessary modifications by Parliament, apply to an international business or economic transaction to which the government is a party, as it applies to a loan. Now, Parliament must do something about it now. Because what, before I get into the merits of the case, I thought, let me just make this point. What this case has done is to basically frighten international businesses when it comes to Ghana. Yeah. I'm not getting into the merits.
Isan Kuma has a fantastic article on it on his blog.
Absolutely.
I Can Ghana. Yeah.
Because he's about
and if what I've heard of Dr. Barr's ruling as well, and he was right to do what he did, because what happens is government can do something unconstitutional and know that once the contract has been performed, restitution will be allowed. Okay, we saw that in the Faro Atlantic case and to some point in the Balkan case as well, and before the CCWL. So what the court is saying that they have actually extremely narrowed the window. You know, and I think he used the word sparingly, because they're not going to allow the Constitution to be breached, and because a performance has taken place, then you allow restitution, or government can then go ahead to pay.
It says it's an almost impossible window to enter.
But it's important that that window should be impossible to enter, because the Constitution says it should go before Parliament. But what Parliament must do is to bring the necessary laws to allow a clear, if you like, differentiation between loans and economic transaction. Because the question may be posed, for instance, if it's an international tender and is won by an international company, what does that mean? Does it fall under Article 181? I would say it does, because it's an international transaction. So should that also go before Parliament? You know, so that is why it's absolutely crucial that Parliament must act and act fast. I understand they don't have a lot of work to do now. You know, this could be something they should, because really it's going to throw a lot of confusion out there. Because then parties, international parties undertaking contracts with Ghana would simply say, we want to use international law. I mean, another jurisdiction. Okay? Or even this, our court can still rule, and then they will take it to international arbitration.
But Nana made a point.
Yeah.
He said the contract was terminated between the government of Ghana and Waterville because, and I know that termination is actually a difficult thing, because there are those who say there was no contract in the first place, so what is been terminated. But after that was done, and Kuku has read the reasons, chiefly being that the preconditions had not been fulfilled, including a main precondition that Cabinet would approve it and subsequently take it to Parliament for approval. Nana is asking the question, when the contract was taken away from Waterville and given to Waterville subcontractors, Micheletti and Consa, was the process followed?
But that didn't have to go to Parliament.
It didn't, because at the end of the day, look, it wasn't a contract between government and Waterville, was it?
No.
So if really I have contracted you as Ghanaian, and then you go to subcontract an international body, I don't think directly one can say there's a contract between government and international body.
Is your question answered?
Well, you see what I mean? So
that was his main concern, and Kofi Adams also agreed with him.
Those issues can be raised, but clearly, I mean, let's also not use all these technicalities to run away from the fact that the claim that was made was bogus. You know, and really, this is what we saw, particularly in 2010, 2011. And we shouldn't run away from that fact, that a lot of stuff went on which shouldn't have gone on. Because the court, I believe, was Justice Doche, who went beyond to even chastise the lawyers involved. And I think they've been asked the matter, the ruling has been sent to the disciplinary committee.
The registrar was ordered or directed
absolutely.
to make a copy available to the General Legal Counsel.
Yeah, you know, so we shouldn't. There's an issue about for Parliament making sure that it brings in the necessary law or regulation to give us clarity in this area. There's absolutely no two ways about it. But that does not run away from the fact that what was done was wrong. And I personally, I am really looking forward with a lot of apprehension to the 2012 Auditor General's report, because I think it will take us to another realm of how our resources have been recklessly dissipated. And really, I mean, yes, because there are a lot of issues to do with this 8 point billion deficit. So we are looking forward to that. But clearly, like I said, Martin, and also it appears the Martin Amidus of this world. The Martin Amidus of this world.
Let's hear Gabi. Sorry. Let's hear him.
The Martin Amidus of this world.
Yes.
Are welcome so long as they are not part of government. And that's also something that we have to look at. Because when he started raising all these red flags within government as Attorney General, what happened? He was booted out. He was sacked.
Yeah, but that is not correct.
Why? He was fired? He wasn't sacked, he was fired?
No.
Or he was dismissed?
Look, listen. If I may permit me, just 1 minute. You see, I think that Kofi tried to draw a line between why some sanctions, political sanctions, were exacted against Martin and the fight that was battling. Look, the Martin's battle had been on for some time, and you see, you have to be in government before.
There was reference to a certain disrespect that he showed to the president.
I mean, at least that's what was done.
For fighting corruption.
No. Let me just you see, I'm saying that it's when you hold public office, then you come to understand certain things. The advice you receive, I think we could say it, and absolutely right. The kind of advice you receive, when you receive it, and all that. I was in government. I had situations where I had a particular officer who would come to me only when I was under pressure to ask me to sign the document. I don't know. And I would say, hold on. Because I had come to know that. You understand? So the ministers and whatnot, past, present, when they are being accused and whatnot, at times, because of the experience I've had, times I just shudder.
But you said they should hold on.
No.
When you're under pressure and they make you feel sign, you ask them to hold on.
In the case of Betty, in the case of Betty Modidrucho, don't forget, after she'd been given advice, and she realized that there was something wrong. She was the one who went to court first to get an order for the thing to be rolled back. She was the one who went before Mr. Tanko
to get the consent judgment set aside.
The amount that was the initial amount that was paid.
But the key question that is asked when that matter comes up is that Justice Tanko made direct orders that pay him only the first tranche. The next two tranches don't pay, and he has to undertake to the court that he will refund. When upon the trial of the case on its merits he loses, he will refund the monies. And yet the state went ahead and paid all the monies to him.
No, but the state is not Betty Modidruso. You understand?
But as the Attorney General, he authorizes through to the Finance Ministry.
Some part of this matter has been run on. People have run over it. And that's why we went to Public Accounts Committee. I say, I have documents. Also, like we have documents to show the particular role she played. The fact that some people also, took advantage of the earlier letter and continued paying without her knowledge. Indeed, part of the money was subsequently paid during Martin Amidu's time. You understand? I'm not castigating him. But Martin, I'm sure, would probably not have known. I'm saying that the bureaucracy has a way of running. And it is easy just to accuse politicians and ministers or something. And I think that
but when it comes to millions and millions of dollars of our money,
I'm saying they can all
you can't use such an excuse. You don't just sign for $7 million or 38 million euros because you're under pressure. No,
I didn't say that.
No, but I'm not saying you're saying that.
No, don't distort it. Don't distort it. I said that those money.
Okay.
Now, final word, if you don't
now I want us, but there's the other aspect we have not looked at, the question of the caution to lawyers and the courts and everybody to be vigilant, and the ages department. We need to discuss that bit of it to end the discussion here.
So I will take that shot.
So let me start with you on that point. And on that point, I'm quoting my notes. I attempted to get them as best as I could. Justice Doshe again says that the lawyers would have proffered different professional advice if they had properly considered the facts and critical documents, such as the letter by Tete and Co., which told the Attorney General, which sought to contradict what Woyomi had written, that Woyomi had written to say about their amounts of money. They were asking for, is it a 20 million plus euros? And Woyomi had also written to say that indeed Waterville is entitled only to 6 million, and he, Woyomi, through himself and Austro Invest and Vamed, were entitled to 5 million. And he said that if they had considered all of these documents, they would have given a different professional advice. And he says, from available documents and correspondences, there is a lot of documentary material to the extent that Woyomi in particular had no business or contract with the government of Ghana. Indeed, counsel for Woyomi would have done himself a lot of good if, while acting for Woyomi at the material time, had interrogated the issues thoroughly. He would have realized that his client was not entitled to what they claimed in the High Court and obtained judgment for. He is now cleverly avoiding acting for Woyomi as he did in the High Court, and now chooses to rather act for Waterville, whose claim his client had denied.
Yes, but this is a very difficult one for me to comment.
This is how he ends. Wait, I forgot. This is how he ends. He says, Waterville and Woyomi, after their initial disagreements, later entered into an alliance to create, loot, and share the resources of the country, as if a brigade had been set up for such an enterprise.
Yes, the last part of this statement, the Supreme Court judge is entitled to his position, his view about it. But with regard to the lawyers, I thought that, when we're looking at all these matters, we must look at the decision of the court. The decision of the court, that the entirety of the court, was that the Supreme Court was not the proper forum to deliberate on the issue of the conduct. So the matter should be referred to the General Legal Counsel. If we take that position, then with all due respect, the comments by Mr. Justice Doche,
the concurrent
comment. Well, this as we say,
is an opinion of the court.
Yes, they are obiter. Obiter dicta, that is, he's entitled to comment, but I think that it still does not negate the fact that the court, the Supreme Court, yesterday said, listen, we have not had the opportunity of going into that particular matter. The General Legal Counsel should investigate. Otherwise, we also open ourselves to charges of breach of audi alteram partem. You see, there may be a record, enough evidence or record there to suggest that if they had so the conclusion would have come to another end. But I think, at least in fairness, let them appear before the General Legal Counsel and then defend their conduct as lawyers. I mean, I think I am at this point appealing to the fundamental rules, of natural justice applicable to everybody, judge, lawyer, citizen, that the people must be heard. You understand? Because, like in the case, Betty Modidusu, it's not in that category. But in the case of Betty Modidusu, she has subjected her opinion to a mediation You see, she had an independent person assessing it. He had subjected her opinion to what do you call it, the Minister of Finance, to the Minister of Sport. They all said there was a contract. What do you expect the minister to do?
What's your understanding of his invitation to the court to also be vigilant when people are coming with such gargantuan judgment debts seeking to take them, and the government, the state doesn't file a defense, and they are coming by, when the time is ripe, they are coming to get a default judgment and all?
I'd rather I don't comment on this, but basically, you know, they went to the High Court. Betty Bolirusu applied back to the High Court.
That's long after.
It doesn't matter.
After they have slept and Reko Bebe will say the horse has already left and you are shutting there.
No, Mr. Okubebe was only yesterday apologizing for some other comment. Don't run him into further problems. But the point about it is that I think it's a fair comment to make. The system itself can be problematic. We have claims which are of 25 years. I've seen people whose properties were burnt at Takwa 25 years ago.
What can a judge do? What can a judge do when you are coming for default judgments?
No, the rules permit if the other side is sleeping, not acting well. But the point about this, when the application comes, and like say what you say, the huge amount, maybe the tendency is to say, okay, let's create an opportunity. But I think that in this case, the judge said, pay a certain percentage because of documents Mr. Wayome showed to the court that he had expended so money. There are records. The judge cannot do the work for the other side.
Okay.
And I think it's fair.
Now, Kweku. Yeah.
You know, this point about, well, it's even connected because there's a conduct of a lawyer here. I won't mention the lawyer in person.
He was mentioned in court, and it's part of the judgment.
No, the particular lawyer I'm going to talk about, I'm not sure was mentioned in the court. But you see, the point I made about consequential actions to be taken, I mean, initiated to a quarantine, what have you, and its assets, those based in Ghana, is reinforced by what happened with Austro Invest. You know, eventually they were struck out of the suit on, I think, is it February
yes,
20th,
because they could not be found to be served.
They had been liquidated.
They are liquidated.
It had gone into liquidation. Okay? They had a lawyer, a very prominent lawyer in this country who is making waves all over the place. Now, this group, this Austro Invest, is owned by one Ray Smith. Okay? I think the wife is the Austrian consul in this country. See, they were supposed to have liquidated the company 26 July 2011. By 19 December 2011, this Ray Smith man was writing a letter to the president of Ghana under the cover of Power Pack. And in this letter, he attached the agreement between Austro Invest and Wayome. And in there, he tells the story of a certain €1 billion that they got from Bank of Austria, not a dollar, appeared in Ghana. Okay? Look, it's a very dangerous situation where you had people around the presidency, people within the Attorney General's office, people within the Ministry of Finance, all facilitating these things. If you go through this documentation, you see an agreement between Wayome and whatever. You see an agreement between Austro Invest and, is it Austro?
Austro Invest.
Austro Invest and Wayome. All put together. And then there's a letter, an advice by the Director of Legal. Okay? Director of Legal from the Ministry of Finance to the Attorney General.
Attention.
Yes, attention to the Finance Minister. Is here? Is here? To the honorable, no, it's to the Minister of Finance from Director of Legal. Okay? It says main issue. The main issue before us, therefore, is the legitimacy of the claim by Mr. Wayome-led Power Pack, Austro Invest, stroke, whatever, for financial engineering cost. people in the system allowed that creation, that octopus of Empower Park, Woyomi, Austro Invest, and Waterville, and succeeded in bringing documents of dubious validity to convince officialdom to the extent that, look, they were able to even to go to a court of law.
When officialdom itself didn't have records of these.
It's amazing.
And they bought it on face value.
The lawyers, you know, eventually Austro Invest went to court with Woyomi. They discontinued the case. Let's find out those who were lawyers for Austro Invest in this matter, in this unfolding saga, and what role they played, and how they played that role. What are you talking about? We are discussing the conduct of lawyers here. Okay, so some lawyers have been cited in court, but for those of us who are going to do analysis, we are going to do the broader analysis. Woyome got his money based on collaboration between Woyome, Austro Invest, Waterville. And there were people in the system as well as out of the system, but belonging to one fraternity who made it possible.
And what is your fear in mentioning names?
Oh, last time I mentioned some name here, people said I was unfair. Even some close friends called me and said it was unfair because the gentleman was not here to rebut. And I said, oh, but we've been discussing so many people who are not here to rebut. I've decided
you're
not
just saying that they have represented these entities. That is not libel.
No, they had documents of dubious validity. They as lawyers knew that those documents were of dubious validity.
I see.
No, but
and then they pushed it.
Was Empower Park in court? Empower Park wasn't.
You don't understand this thing. You see, you are trying to be.
As a lawyer, let me also caution.
No, that's why I haven't mentioned. Look, I have not even gone far.
So don't go. Don't even go.
Listen. You see, look, this letter dated 28 May 2010 from Ministry of Justice to the Chief of Staff. It's copied to the Chief of Staff, but it's addressed to the Minister of Finance. If you go into this letter, the letter gives, see, it is still my position that we pay Mr. Woyome and Austro Invest the negotiated amount of so and so and so. We had officially accepted Austro Invest as part of the deal when there was no documentation to that effect. That's the point I'm making.
No,
and it did not take only lawyers who were in private practice and defending these clients, but it took also people who were in official positions at the Ministry of Justice and Attorney General's Department, as well as Finance and Sports. How come they didn't see things that we had seen already? Look, many newspapers,
If I can,
many newspapers had seen all this. Those of us who are not trained as legal minds saw through these things. It must be collusion.
You are trained to intercept documents.
Please, no, sir. Let me make this point. You see, I think Kweku has a lot of information. I think that I will share a lot of what he said.
Martin Amidu says this information is already out there. He got it outside. It
doesn't matter, but it's a question of being responsible. No, it's a question of being responsible.
I know where he got it.
Look, in what we say.
It means it wasn't available.
Let's hear Nana.
Please, I think this should be this is a disciplined outfit.
Okay.
What we say can be done.
That is so.
Please,
gentlemen, hold on. Let's hear.
You see, the Supreme Court. What are we talking about? We are talking about Waterville's case.
That is so.
That's what. That's what you're now. Now, just a minute. Oh, please. I'm saying that. I'm just saying that yesterday, the Supreme Court itself, when it came to the issue of Woyome, what was the decision?
It says because of jurisdictional matters.
Exactly.
And for the fact that the matters are already pending before the commercial court and the financial court. But this is what he said.
No, but if I may just say.
Yeah.
So, however,
I want to read you that line so that you will be guided going forward. Yeah. It says that under the circumstances of this case, then it comes, there's absolutely no claim for them to pursue. Then he says that, however, since I fully agree with the decision of my brother Dateba, JSC, not to grant the reliefs against the third defendant, that is Woyome, basically because of jurisdictional reasons, I will echo the sentiments that once the matter is pending before the trial high courts, namely the Financial Division and the Commercial Court. It is the expectation of this court that the principal actors in those cases will put up their best in the pursuit of in the prosecution of those cases.
Yes, that's exactly. You understand what I'm saying. So the point I'm making is that Woyome may be your devil, you see, but at least he's entitled to his day in court. And the Supreme Court rightly said that, look, Woyome's matter is before us, but because of the pendency of those three matters, we will not, come to a conclusion. Let them raise that one. Now, what Kuku is doing here is raising so many other related matters, which the Supreme Court had, quietly declined. I'm saying that we must.
You're not being fair to me. I'm not emphasizing the Woyome case. That's not. We've been focusing on Waterville.
Yes,
incidentally, you see, there's a connection between Woyome and Austro Invest relative to the Waterville claim.
Yeah, but I'm saying that
it's not the Woyome matter that we are discussing.
Yeah,
really?
but no, I agree with you. But I'm saying that at the heart of it, all these Austro Invest, whatever, they are matters pending.
They could write to a whole president.
I'm not saying that he's right.
The president that they have documents, and these documents are sent to the presidency.
We
are in trouble.
If they wrote, what makes you think that
I think we should be disciplined about it.
All right, gentlemen. Now, let me have you briefly on it. The caution is that everybody ought to see that there's a bigger Ghana that we all must owe a duty to, and that is where we should be looking at, and to our conscience. There are some who are saying where IOCO failed because they came in, where state institutions, the Attorney General failed, and then the IOCO came in, they all failed. One single man, Martin Namidu, has been able to bring this nation, has been able to procure justice for this nation in this matter.
Because he was commissioned.
Sure. We all happy for that. And I should say that I'm happy for the new face of our justice system. Not too long ago, you remember this SOX issue also, where the Attorney General went to court and saved the country a lot of money. So it kind of gives you some understanding that the justice system or the Attorney General is not up to its task in terms of saving this country. Millions of dollars and euros that goes as judgment debts or for works that have not been done or even contracts that should not have been there. We have talked about, I've been trying to get Kweku to get me lawyer Tete's letter. You know that letter itself was not directly saying that certain things were not due even Waterville. He was trying to deny Woyome's letter saying that he together with somebody were due so much and they were due less.
No, that letter, the content of that letter, as far as I remember, was to the effect that Woyome is claiming so much before you. We are here to tell you, and they actually attached to that letter agreements.
The termination agreement.
Yes,
agreements.
Mutual termination between them and Woyome, and for which Woyome had received payment. So he had no claim.
He had no claim.
Exactly. Meanwhile, they were also claiming further
but they have
amounts.
claims. Yes. They have claims. So we should not base it as if Tete was out there to save. To save
that is what raises the judge's curiosity that the two who disagreed now came together.
At this,
singing the same song and getting the money.
At this moment, the side he was defending that they have a right to claim certain amount of money, the Supreme Court has made a pronouncement that they were not entitled to it straight away.
Okay.
So
final word to Gabi. He hasn't spoken on this.
Just to end, what we were talking about earlier was that you remember when Waterville was making claims. Waterville was told that some monies due them for works done has been given to Consa and Micheletti, and that they should go and collect these monies from these two institutions.
Which they did.
They had collected already.
For what? So the question now is, what work were they collecting those monies if the so-called contract for
the work according to the court, what they paid for according to the court.
We are told.
Listen to him.
What the court said according to that is that even before the contract was signed, the two agreements of 26 April 2006 were signed. They had been asked that the minister had no objection to their going to site to start work. So they went to do demolition of structures, clearing and excavation works. That's what they were paid for.
At that stage, Waterville is no longer an international company whose activities must go before Parliament. Is that what we are saying?
That is why the Attorney General says at this point we are terminating because you have gone on to start work.
But I'm saying
where
that
the contract has not come into effect.
It means some wrongs dated back and which affected
people don't want to accept the reality.
The man's difficulty is this: he's seeking is a poor attempt at equalization.
No,
that's what he's doing. That's what he's doing. But it doesn't answer the question. This is a very serious matter.
I never engaged in equalization.
That's what you just did.
If the contract
with difficulty, you were bending backwards to bring in that.
If the contract
is of no material effect. Listen, we now even have to question. We have to question the basis of the mediation.
No. He's been unfair to me.
Okay.
Look, the mediation.
Look, why? It should be fair to me.
The mediation process was also led by a lawyer.
The court pronounced on all those.
The court did?
Yeah, briefly.
Okay.
Briefly.
To me, really, look, this, $40-something million or so?
47.
Yes, and the judgment debt part of it was how much? That was about 20-something million euro.
Yeah.
Or 30 million euro or something.
The figures are too many. Sometimes they confuse me.
Now,
how much had been
in
paid before?
In the last 2 years, Waterville has made a lot of money from our money, on which it wasn't supposed to even be in their hands. Okay, we need to also look at it from that point of view. Okay, so let's just hope that they invested it properly, and they can pay us back.
All right,
Gabi.
On that note, we take a quick break. This is Newsfile on Joy 99.7 FM. You're also watching us on your Joy News channel on Multi TV. I'm Samson Ladia Yanini. This show is brought to you by the kind sponsorship of MTN, Everywhere You Go, and Bank of Africa. And my shirts is provided Kind Kesi Latida. We'll be right back. You're welcome back. This is Newsfile on Joy 99.7 FM, and it is brought to you by Bank of Africa, as strong as a group, as close as a partner. MTN, Everywhere You Go. And for you to have a nice shirt like I'm wearing, call Latida 0265 6509 18 or 0204 336 444. And some of your text messages or your messages on Facebook, let me attempt to read some of them. This one says, Derek Ado says, Samson, I heard in some other jurisdiction, when a lawyer goes to court knowingly before that his client has no case, the trial judge could fine the lawyer, and the lawyer could sometimes even lose his license. Does it happen in Ghana? Exactly what the court has done. They have so Motu referred the matter to the General Legal Counsel for onward submission to the disciplinary committee of that council to be dealt with. Then, all right. Please let your comments be decorous. Otherwise, you have kicked yourself out already. Abdul Hamid Mohammed says, it is very obvious to hear Nana Ato saying that Betty performed professionally. This woman, okay, what you're saying, I can't repeat that on this network. I'm sorry. Seth Awochi. Okay. Seth Awochi says, Martin has done good job, but let us ask ourselves why our parliament refused to do due diligence on the issue before it's guaranteed it generated into this stage. Of course, you are not, maybe you sent this before the other part of the argument. This matter has not actually gone before them. So I think you have to leave Parliament out. Kofi Adoli says, no matter how an elephant dances, it cannot climb a tree. Its ability to see better and further is dangerously limited. The accolades being heaped by the NPP's activists on Martin Amidu beg the question of responsible citizenship. These were the people who walked over the Parliament of the people of Ghana and signed a contract with Waterville against the requirements of Article 8185. And this is what Martin Amidu sought to correct. Should the NPP not be remorseful. Now they praise Martin Amidu like a choir. Amazing. That is Kofi Adoli sending in that one. Karim Ahmed Bediako says, I agree with Malik that the state must move in quickly on Waterville to make sure they do not run away from this country. But the most important thing right now, in my opinion, is for the security to arrest Madam. Okay, sorry. The portions that the court did not rule on, please, let's stay away from that because it is very important. We took note of that, and that is why we didn't go into that. I want us to move on to the next issue, but when your messages come in, I'll try and read them. I am directed by the production. Now, before we go to the next issue, I want to bring the last part of the quotes from my notes that I took. And it says this, quote, the lawyers have a duty to the ethics and their own conscience, that lawyers should pursue claims not only legitimate, lawful, just, and legal, but reasonable under the circumstances of the case. Thank you very much. Now, let's go back to still stay in the Supreme Court and talk about the Supreme petition, matters that came out from that in the course of the week. As you know, it's been adjourned to the 24th of this month, and the adjournment has been occasioned by the inability of KPMG to complete the cross-checking audit that is supposed to do in respect of the pink sheets. And there were also warnings that were given to the lawyers in the matter to be sure they stay away from the wrath of the courts. On this note, I'd like to start with Nana Tadazi. Nana, we are back at the issue, aren't we? Back at the pink sheet counting matters. There are those who are afraid that we may never get to an end. I've asked this question before because now they're going to use the Justice Atugube's copies to cross-check what is in there, and they are saying they need 1 week and more.
Well, yes, except I don't share your optimism, you know, pessimism.
It's not mine. I am echoing the sentiments of people.
If we just quickly roll back, you know, this matter, right from the beginning, the respondents, that is the NDC and all three of them, indicated that they hadn't received more than 8,500 or 9,000, pink sheets. And the very first day we were in court for the memorandum of understanding, for memorandum of issues, the first thing that was requested was that there should be an audit. That was the first day. Our friends, the petitioners, objected strenuously, and the court said, well, they thought it was premature, so we should defer the matter. If we go on and it becomes obvious, well. But I keep saying that pink sheets, this whole matter is about votes and vote annulment. The petitioners seek to annul 4.6 million votes of their respondent, first respondent. Now, the votes are captured in the pink sheets. So, depending upon the number of pink sheets that the petitioners attack and are able to knock out, you know, then
reduce the numbers.
Exactly, they reduce it or upgrade it. So when they say we've given you 11,000 total, now 11,138 pink sheets, and it turns out that we've only had 8,000, maybe 500 pink sheets, with so many of them with duplication, triplication, quadruplication, then you know the whole issue becomes something else. So it was important right from the word go to ascertain the number of pink sheets or the number of votes that we were talking about. But well, be it as it may, got to the tail end where they said KPMG must go into it. KPMG started its work, and there were challenges along the line. the respondents complained that even though there were 24 boxes, subsequently some 10 other boxes or parcels had been added to it. True or false, that is a matter. They've counted all of them. All the 34 boxes, I believe, have been counted. Still, there were challenges. So it was said that the control document, that is the independent document which all the parties had agreed to, should be counted for avoidance of that. It's been done. You know, it's the whole point about it, you have to key it in. It's a lot of work, keying in, making sure the figures are right or whatnot. But it is open knowledge that the figures would appear to be nowhere near.
What in your estimation is the latest this case might be over? I mean, the trial might be over.
I think that this trial will be over pretty soon. I mean, the way I see it from my own perspective, I mean, what is left is with the KPMG report. Once the KPMG report is tabled, any party...
Addison has not finished his cross-examination.
Well, I'm coming. Well, the question really is whether Mr. Addison has any other questions to ask. You know,
you are objecting to his use of the pink sheets he needs to use, so he's waiting.
No, which clearly means that there's a roadblock. The pink sheet issue, which we raised very early, has come to revisit us. You see. So all of us, Chachu Chikata hadn't completed on account of the pink sheet. It was absolutely right, you know. Now what is happening is that the pink sheets will be the report, KPMG report, will be tabled. Then, under the rules of court, either party is entitled to, you know, ask questions on them. If there are no major questions, the document is adopted, and then the cross-examination of them will follow. Really, I don't expect too much by way of cross-examination. And then we will have re-examination, if any.
All right.
Then we'll go to addresses.
Okay, the president is on record as having made some comments that are thought to be prejudicial. Samuel Kujeto, very respected learned senior, has condemned him for it. He says it's very unfortunate that he made those comments. Let's hear the president again at the anniversary of the NDC, and then I'll come back to take a comment on that.
I thought that there wasn't a finer time than today, marking the 21st anniversary of our party, to visit the party office and to express my appreciation for the work that is going on, and to encourage you to continue with the good work, and to also encourage you that our victory was won cleanly and fairly. And that justice will be served and cannot come to any other conclusion than acknowledging the very transparent, free and fair victory that we won at the election. The case continues to strengthen the base of the party, because it is the base of the party that supports government to be able to carry out the manifesto that the party took into the campaign. And so I won't say too much, but just to say that I came for us to have a little tete-a-tete just for a few minutes, and we'll continue with the work that we're doing.
All right, His Excellency the President John Dramani Mahama, and at the party's 25th anniversary. Oh, just what's it?
Yeah.
No, hold on. I like the way he says it, party. Now, Nana, this comment that he's made, a lot of people have, you know, gone at him to say it's wrong. He should not have said what he said.
I completely disagree with the people who said this. First of all, we must look at the forum where he articulated this. This is the first respondent addressing the third respondent on the occasion of their 21st anniversary at their party headquarters, I believe. Of course, they should be talking about challenges facing them. The agenda should also include, you know, the court case. How else? What else? Which other forum? I can understand people attacking him if he goes into the castle, the what do you call it, flag servers, and is blowing this kind of matter. This is an in-house matter. If the press have given it, voice, that's another matter. But as a party, as a first respondent, he's simply saying, I'm confident that I have a good case. I'm confident that I was properly elected. And I'm saying, he was addressing the third respondent.
He's not only the first respondent, but he is also the first among equals in this country.
Absolutely.
By the constitutional arrangement, he comes before everybody else.
Absolutely. But that line is also there. I'm saying that if he had gone out elsewhere to say it as another matter, but what you fear when to me in sorry, you should be able to speak to your children when you go home. Daddy, what about this case in court? So, well, as far as I'm concerned, I know that I was elected properly, and I'm quite confident that
the court cannot come to any other decision.
But I'm saying it doesn't matter with the amount of words he uses. But let's quickly say this. The two quick matters. One, he is on record outside this forum to have said that he will abide by the decision of the court, isn't it? He said it every time. And then the second point I want to make is that for all those...
But now you know the decision he's expecting,
No. Of course. Of course, otherwise he wouldn't be standing out there.
He knows that by this comment,
he
he knows that is the only decision that ought to be arrived at.
I'm saying that it's an in-house discussion, but just let's not also make that. Look, after sitting in the Supreme Court as in 2 months, listening to this case, following the rulings, 8-1, 7-2, 5-4, and whatnot, I think anyone who appears to be stating that, the Supreme Court will be wooed or intimidated by the president's comments rather has a problem. Then he means that he does not have confidence in the Supreme Court. The panel that sits down there, I remember Justice Sule Badegbe at a point in time when some comments had been made. He said that you can poison the public. You remember that? With toxic material. But let me tell you, no one can poison this panel. It's the confidence that the Supreme Court has exhibited. So I don't see why should we are afraid. I've heard people also threatening in the Supreme Court if they don't take this decision or they'll do this and all that. I have confidence in this Supreme Court as presently constituted. They've done so well. They have to be supported. They are elderly people who in 2 months have not asked to a case to be adjourned on account that one of them is ill or whatnot, high or low, they come to court. And we must rather look for the things which can back them to stand firm and firm.
Abdul Malik.
Well. The pin sheet matter and the control mechanism, I think we exhausted it last week, so I would not waste too much energy on that.
Okay.
We shouldn't have been where we are, to be honest with you. For me, it's an embarrassment to the system, to the nation. But the president's thing, because he's the president, maybe, just maybe, there's a distraction, just maybe, people think it might sound politically incorrect, but I don't see how much impact that can have on the proceedings and the outcome. So I think it's judiciary of not much value for me in terms of effect. So that's the way I look at it. But it might, because he's the president and because he's a party to the case, it might sound politically incorrect. I remember, and this is slightly a different scenario, but I remember when the famous 5-4 victory for Mr. Chikata happened and Mr. Kufuor asked for a review. He first described the decision as a bit strange and asked for a review. And then also before the subsequent 6-5, when the optimisms were expressed by Akufo-Addo and Kufuor to the fact that there was an exceptional error, so they believed we change. There were problems. There were people on the side of Mr. Dazi who didn't think that. Oh yes, who didn't think the president ought to have made those comments, because he is the president. I think it's within the same context. But really, to be honest with you, I didn't put much weight on it. I don't think that it will derail the judicial processes or have any effect. So in my candid opinion, there were people I heard complaining, and I had heard those people also predicting victory for their side. Yes. I'm avoiding them. They are not presidents, of course, but they are still very significant personalities who are part, whose interest have an interest.
Some of that in court, that some have said that by Easter or whatever, Nanado will become president.
Yes, I mean, the general secretary of the NPP had heard him declare victory and all the rest. So I thought that, look, don't take this out of proportion. I think there was a certain out of proportion reaction, some overreaction, and some element of selective amnesia. I wouldn't waste too much time on what the president said. That's my candid opinion, because it will have no judicial impact on the proceedings as well as the ultimate outcome.
Kofi?
Yeah. Thank you very much.
And you two are on record as saying that it will be easier to get the voter lake to run
to reverse
backwards,
flow of the voter lake than to
and then Felix Ofosu-Kwakye is also said to have put his life on the line, that he swears on his life that this case will be won by the president.
Let me say, I wasn't on this platform last week, so I would have to say something little on the issue of the pink sheets before moving on to this part. I think I heard my colleague, there was a report about Kweku talking about the possible compromise of the...
It was a question.
Yeah.
It was a question.
Because that question was needless.
Really?
Really, coming from him, it was a needless
Where are
question.
those pin sheets kept? Atukuba's pin sheets, where are they kept? Justice Atukuba's pin sheets. Where are they kept?
I say so because...
Who keeps them?
Because before the count started, the parties have agreed to the use of the president of the court's copy as a control.
Yes, and were they quarantined?
When the process began and the first, third respondent saw that boxes of pink sheets have increased and they came back to court to complain, they even added that instead of using just one justice, in this case the president of the court's copy as a control, we should increase the number of justices that
are their copies kept?
Please,
where are they kept? Answer that question. Who keeps them?
Please.
And how?
This was the position of the respondents' lawyers when they raised the matter, that if we could increase the control, it was shut down. That no, they should go back, send their issues to the referee, and if they have any concerns, they will raise it. It means reverting to the old use of the president of the court's copy as a control. Kweku was in this country at that time. He didn't see anything good in what the respondents were raising about increasing possibly the number of justices whose copy will be used as what? Control. Now we got into a point where the KPMG was to use the presidents of the court's copy as a control. Then you come and raise the issue of possible compromise of copies because you think that they are kept somewhere.
Who keeps them? Answer me. And where and how are they protected? It was a question I asked.
I'm saying that
the control mechanism, that those documents should have been given straight away the first day to even the referee.
Okay.
That is what the president of the court said. In fact, the panel said they thought it was part of the order.
But it did not. The fact is that it did not happen.
It
did not. It did not.
They said they're surprised, shocked. That is why when Mr. Addison was insisting, look,
were those copies given to the referee?
No, I'm saying that the entire panel said that they didn't think it was necessary even to write it.
Mr. Lazi, you are not understanding me. Were the copies given to the referee?
All right. Let's hear Kofi out.
I thought that it was a comment that should not have been made.
It wasn't a comment, it was a question.
Or even a question that should have been asked by no less a person but Kweku Bako of all persons. I think that he shouldn't have gone there at all.
I'm amazed.
I'm sure you'll be amazed. Now, coming to the position of His Excellency the President. We have had President Mahama speak from Flagstaff House as far as this election petition is concerned. When chiefs called on him, when Otumfuo also came to him, when he addressed Ghanaians in France and all other places, he has continued as president to say that he will respect the outcome of the ruling. There's a difference between speaking as president to the people of this country and coming to address your party as leader of the party. He has never, either at the Flagstaff House or any other platform that he has addressed as president of the Republic, saying that this and this and this is the case. He came to the party headquarters as leader of the party. He has sworn, there's an affidavit that has been sworn on his behalf by Johnson Asiedu Nketia, where he contests what the petitioners are saying, that he won a clean, fair election. So there is an affidavit. He is only re-echoing the position abused in the affidavit presented on his behalf in court. So he has not said anything except for the fact that those who are criticizing him maybe are wearing plywood goggles.
Plywood.
They don't see anything on their side. I think that it's really unfair criticism of the president, who is home, who has visited home and addressing.
For those of you listening on radio, what is happening that is inviting all of this laughter is that Nana has picked Gabby's spectacles and is surveying to see if it is plywood goggles to give it to Kweku.
It is true, like Kweku said, that when President John Agyekum Kufuor in faraway Australia then raised concern about the outcome of this, that was a case that was Republic versus Chachu Chikata. And here you have a president performing official functions out there.
The first round.
Oh, of course.
Yes.
And he's saying that it's strange and that he's going to order his attorney general to do everything possible. Yes, to do everything possible. He was speaking as president.
To seek
review. He was speaking.
It was his option.
He was speaking as president. Subsequently, the attorney general also picks it up. That is different from an election petition where the president is indeed a respondent.
He's telling you that matter was not pending in court.
Where indeed the president is a respondent and is a direct party. And affidavits have been sworn on his behalf, where he has stated certain issues and certain cases. So people cannot be comparing the two. They are not the same. They can never be the same.
Like Kofi Adams is saying, what is new about what the president is saying? We are aware that this is the position of the president as a party. So what's the big deal?
I think what he did was absolutely necessary. For the obvious reason, he has seen, after all that he said, I'm talking about Asiedu Nketia, his witness, eventually a tape was played to him where he himself admitted that where people don't go through biometric verification, the agreement was that those votes must be annulled. He heard that. That was the last thing that was played in court. After all the things about Choboy and transpositional thing can be this, can be that. That was the conclusion of Asiedu Nketia's testimony. He's heard the chairman of the commission admitting to overvoting, also creating some confusion as to either or, whether the figure in C1 and C3 are the same, either or. And all these things he has heard. Obviously, his people were worried that how is this case going to go? And on the occasion of their 21st birthday, which the party, I believe, is now an adult, we hope so, we're yet to feel it, it was important, in his view, to give them some hope as to how substantive that hope may be. That's up to the court to decide. So I will take it from that point of view. His supporters obviously were probably down, and he needed to say this. I'm not going to read too much into it. I would, if you don't mind, like I said, really, at the end of the day, I think these things being said are not going to have any material impact on the judges. You know, the president can say so to tickle the fancy of his supporters. And of course, I mean, you know, when you're under such pressure, you know, considering the numbers involved, you need to say something. You know,
Is it the case that is it the case that you are unable to speak otherwise because there are members in the NPP, very important members, who have made similar comments?
Let me tell you what just Thursday, BBC wanted to interview Akufo-Addo, had discussions with me in London, and they wanted to ask matters about this court case. And he said, look, I mean, I don't want to speak on this. So that's the decision that he has taken. And I'm sure since even the amended petition, you haven't heard Jake speak at all. Since this trial started, you would not hear Baumia speak unless he's in the box. It's a decision they have taken. It doesn't necessarily mean...
Because they have spoken enough long before this. They have said so many things.
No.
Their Lisa addresses and all that.
Sir John
the press
is
conferences.
Sir John is enough.
And the general secretary every day.
The Lisa address, and I said since, you know, I said since the amended petition, the Lisa address was limited to telling the public what was contained in the petition. And if you notice, I haven't really criticized the president's statement. As far as I'm concerned, you know, he can go and tell David Cameron the same thing. It wouldn't make any difference. He can go to G8 and, you know, sometimes I feel sorry for him. You know, he goes to all these international conferences. People are like, hey, this is the guy who's been challenged. You know, so he can be saying all sort of things.
Is that
to
the
all
intent
sort of
the challenge?
No, I'm just saying.
No, is that the intent of the challenge? Or?
Come on. Can you, let's be serious.
Okay.
Let's be serious.
Yeah, but
yeah, he can, and it's very important for him, for his own psyche, for his own psychology, for his own well-being, and for his supporters, that he tells them things. I mean, you know, he can say whatever he likes. You know, that the court can only come to one conclusion. As far as I'm concerned, you know, others can also make political gain out of it.
In
because
fact, you are making a political statement now.
That he's a party to this suit. Secondly, he's the president, and you know the separation of powers, and he ought to speak more responsibly, and I think that's also fair game. You know, but the bottom line is, I think the 9 justices, they will deal with the evidence, and if I can perhaps move on, if you don't mind, because I really don't want to, I don't think...
Okay, if you're done with that, let me take some text messages. This one from the CPP's Kabila, he says that it's good that for the respect of procedure under the rule of law, the Supreme Court, which is the highest and last court, declined to decide on the Woyomi aspect of Martin Amidu's claims, deferring so to the High Court. However, I am happy that a hint has been offered that wrongly paid money could be retrieved, and the judges of the law certainly would guarantee that. Kudos to Uncle Martin for proving President Mills and Mahama wrong in this wrongful payment. Kabila, thanks for that message. I read some others that you sent to us here, text messages. This one from Zakaria Safiano. He says, this is a lesson for civil society groups who, instead of who could have given moral support to Martin Amidu when he was fighting the case, they rather kept mute for what reasons best known to themselves. Now turn around to praise him. Civil society groups must stay away from politicking allegiances to the servants of the ordinary Ghanaian who needs them on their side than always sided with corridors of power. Okay, so you see, this is what I always say. When you type the message, take your time, read it over and again before you send it. Otherwise, you make a lot of mistakes. Martin is a modern hero and must be celebrated. Now, this kind of name, political guru, you are sending this from Amsterdam. You say, Mr. Martin Amidu should be giving the highest, and please, next time, use your real name or else I won't read your message. Mr. Martin Amidu should be giving the highest state honor as a citizen vigilante, as he is affectionately known. He single-handedly retrieved for Ghana 47 million euros, which was an unjust payment of judgment debt. Mr. Amidu stands tall out of all NDC members and has no equal whatsoever when it comes to truth and honesty. Mustafa Abdullahi writes, good work done by Martin Amidu, but I can't understand why an institution can be lackadaisical on one hand and turn round to be so-called serious on another hand on the issue of Waterville and Woyemi. We must be hard on those officials who, on their unprofessional conduct, allowed our motherland to be stripped naked as far as our revenue is concerned. Let's begin to crack the whip. Yaya sent this one from Tamale. He says, all Ghanaians should develop a mechanism to ensure that the money retrieved goes into the public purse, but not into the pockets of greedy bastards. Otherwise, this landmark ruling will be useless. Amo Silas Samuel writes from Kenya, say, in as much as Martin Amidu has succeeded in the Supreme Court, we should also ask ourselves what our state institutions and officials have been doing. What would have happened if Martin had not gone to court? Osafo Amankwa, forgive me if I didn't get your name correctly on the first attempt. What happens to interest paid on monies to the state? What also happens to the former AG's alleged conspiracy to defraud the state jointly? I am a bit surprised at the controversial judgment, leaving out the criminal aspects of fraud and not punishing culprits. Okay, I'll take this one. Muhammad Muntala of Edukrum, Nima, Kumasi says, why is it that Martin Amidu's successor didn't continue what Martin Amidu initiated in respect of the case? Well, Martin Amidu's successor continued what Martin Amidu started. Eric in Accra says, Samson, did the court award cost to Martin Amidu? No. The court said there will not be award as to cost. A final message from Solomon Akosa. He says, Samson, did I hear Nana Atodazi say Betty acted professionally? I bet. Okay, I think you sent this one also to Facebook and it has been read. Thank you very much for your messages. And we'll still continue briefly. I understand we are taking a break. We'll be right back. Welcome back. You're watching us on your Joy News channel on Multi TV. You are listening to Joy 99.7 FM and over a dozen affiliate stations across the country, and also at myjoyonline.com and Multi TV World /streams. And Kingsley Kofi Kakari Bonzi writes, it's very sad that as a nation we keep good people like him from government but award some or other people as ministers, whilst we are going around the world looking for loans as low as USD 10 million to develop this country. Martin Amidu has just won us 47 million. Kudos to him. And Oscar asked the question, why did Martin Amidu not ask for interest on the amount? I think it was somewhere there in the declarations as well. Safwedu Kwame writes, Dr. Kwabna Dofo, Betty Moldedrisu, and Bo Batinedro should be arrested and charged. Okay, let's stay with just those other matters. The very final one I'll take here says, Samson, can you please tell Kweku Bako to put his bunch of documents under the table or by his side, because it is blocking our view? Why, you want to watch which part of him?
Blocking their view.
Yeah. Which part of him do you want to watch?
Was that from a lady?
I will oblige next to me.
A lady.
Gentle Mike K. You simply say 9 shirts. That's all. Great. I've shown you where to get it. Latida 0204 336 444. Thank you very much. Now, gentlemen, let's look at the judges' warning. They gave a warning again, and this time they said, let's clean the slate for the very last time, and that the whole world should be witnesses. The next time, you are either going to be cited for contempt, or you are going to be referred or handed over to the General Legal Counsel. Gabi.
I think the justices should ask themselves one question. If lawyers in this matter, who are supposed to be officers of the court, are behaving with such passion, okay, and can be that unusually cantankerous, what about the people out there? Now, I'm just saying, you know, it's really what this case means to the country. And the lawyers themselves know it. You know, so the passion that comes with it, okay, is a reflection of how critical this case is to our democracy. So that, to me, it doesn't mean it gives you room to be unethical. But I'm saying that the justices themselves should appreciate what this means.
This time it was your lawyer who was caught.
Well, I mean, what, with what, tamper-proof bags or what? No, I'm just making a joke. Well, to me, it matters not. It matters not who was caught. The important thing is that the lawyers know that, look, the destiny of this country somehow is going through their hands. I'm not saying it's in their hands. It's going through their hands. And to the justices up there to make a final determination on it. You know, so if they are overly passionate, if they are showing a lot of emotions, it's really a reflection of the national atmosphere and the environment under which they are operating. So that's what I will have to say. But it's also, you know, what I've noticed is that it appears the strategy of the respondents may be down to twofold: technicalities, and secondly, see what we can do to overturn. Not to allow this result to be overturned, but if need be, if you listen to Chachikata's questions to Afarijan, it was basically, okay, so if the votes have to be annulled, what about other things that are not even in evidence, or other places that are not in evidence? So it's like, if we can't use technicalities to basically throw out this case, then let us see if the whole elections can be annulled.
If they are legal technicalities, why not? They are doing it lawfully.
But let me just remind Ghanaians of something. In 1993, this was the first after Kenya has returned to multi-party democracy, as we did around the same time. The opposition leader